Good morning, members. Good morning for those of us that are joining us online. Today is Wednesday, July the 9th. This is the regularly scheduled Collection Service Board meeting. My name is Roxana Gamusio. I'm the Executive Director with this board. As first order of business, I would like to go ahead and take roll call vote. We are starting promptly at 9:31 this morning. Members, thank you for being here. If you'll let me know once I read your name to make sure that we have quorum. Jason Hill.
Present.
Tony Zakovich.
Present.
Thank you. Chip Hellman.
Present.
Thank you. Greg Zaworski. And Ms. Lori Hadwig let us know that they were not able to make this meeting, but we do have quorum in order to proceed. Notice of this meeting was posted to the board's website since July of 2024. Additionally, this current agenda has also been posted on the website, and that's been on there since July 1st of 2025. Individuals that wish to make a public comment regarding any of the items on the agenda can do so with the new order of business at the end to make sure that they've got time for comment or any questions that they might have. We'll make sure to allow for that time toward the end. Members, as the first order of business, on your iPads you have the minutes, but the first thing is to approve the agenda as it's been presented unless you have any changes.
Move we approve the agenda.
I second the motion.
Thank you. We have a motion by Chip Hellman and a second by Jason Hill. All those in agreement, please say aye.
Aye.
Any opposed? Hearing none. We will proceed to the minutes. Members, this was emailed to you along with the agenda and the redacted legal report. If you've got any changes, please let me know. Otherwise, it is on your iPad, and if there are no amendments, I would need a motion to accept.
Motion to accept.
Second.
Thank you. Motion by Jason and a second by Chip. All those in agreement, please say
Motion
aye.
was by Tony.
Oh, Tony.
Yes.
Second by Chip. Writing faster than my brain's going. Thank you. All those in agreement, please say aye.
Aye.
Thank you. None opposed. On your iPads, members, you've got the budget information, and I will give you that page number in just a second. This is that informational piece we discuss. The numbers are through May of 2025. This reflects the profession at a deficit of $82,460. It is placed our reserves at $636,962. Nothing different from what we've been discussing regarding licensing. No concerns because the substantial amount is in the reserve. So let me know if you ever need anything more than that information provided. The item that I've got right after that on your iPads is the suggestion for 2026 meeting dates. These dates can be changed if we run into or have a need, but basically they're following sort of what we did last year. We've got January the 7th, April the 8th, July 8th, and then October the 7th for our 2026 dates. I would need a motion for those, for that approval, and then obviously we will update the website.
I move we approve these dates for 2026.
Second.
Thank you. We had a motion by Chip and a second by Jason. All those in agreement, please say aye.
Aye.
Any opposed? Hearing none. That takes care of my side on order of business. I will turn it over to our attorney, Joseph Wardham, for the legal report. Thank you.
Good morning, board members. The legal report for this meeting has a total of 21 cases on it. I'll let you review that, and then I'll read the complaint numbers into the record after answer any questions that you all have. Based on the recommendations, currently I've recommended 6 consent orders, which is a larger volume than our normal legal report. As you will see, though, the consent orders are tied to direct statutory violations as far as licensure, surety bonds. So I'll go ahead and open up the floor to you all for any questions on these cases.
Well, I have a couple questions.
Okay.
If you don't mind, Joe. First off, I noticed this legal report, we are listing the name of the respondent.
That would be a mistake. It normally would be redacted. So, yes, when we post it, it will be the redacted form. So if you have a conflict with any of them, let me know, but you would normally not see the name of the respondent.
Okay, but I think, so I'm just trying to follow this logically. I think for the purposes of us approving the legal report, it would seem to me that we need the name of the respondent, or we would not know if there's a conflict.
The way that we've operated up to this point in time is that when a legal report is presented to you anonymously, we believe at that level of just reviewing a complaint before any choice has been made as far as litigation or legal action, that there would be no conflicts at that level. But then,
Because there is no respondent listed, there is no conflict, because I'm voting, if I'm voting on my company, I don't even know that.
correct.
Okay,
And then essentially, if after that legal report has been presented, if the board would have decided to move forward with like a consent order, at that point in time, if we knew of a conflict of interest with a board member, we would then reach out and basically say, hey, this case is moving forward with formal litigation. If it's represented to the board, the request would be that you step out of the vote or
okay.
remove yourself.
So then a Robert's Rules of Order question. So let's say there were just three of us and we were proceeding, but one of them had a conflict. Does that take us out of quorum for that matter?
I believe so.
Okay.
Yeah.
So in those cases, if we know it's happening, we have to strive to have at least 4 members present for the meeting, because one is going to,
Which would be alleviated if it was anonymous, correct?
right. Okay, but it, yes.
Like, we could move forward with 3 when it's done in the correct
Okay.
fashion, where you have
Okay.
no names and just licensure information. And then, in this particular circumstance, I think your point is warranted.
Okay. So, thank you for clarifying all that. So in the future, the respondent will be left blank like it
Yes.
always has.
It
in the
always
past.
has
It
been.
should
This is a
have been
mistake,
this time.
yes.
So that was
Okay.
a mistake.
That's
Yes.
fine.
Yes.
It was kind of fascinating to me, though, to see there are multiple repeat offenders on this list.
And you normally would see that they're repeat offenders, you just wouldn't see the name. So nothing is different, you just wouldn't
Okay.
see the name of the respondent. That's all that's there. The other piece is, back to your point, if legal receives a response, once you've made a decision on the complaint and we know that you could have a conflict of interest, we would make sure at the follow-up meeting that we had all 4 or 5 members to make sure you had quorum, yeah.
Okay, great. Then I have just a question about Tennessee law related to case number 1. I know that case number 1, the recommendation is a consent order, but it really involves, as all your consent order recommendations, statutory violations, as you said earlier. My question is a hypothetical one. Forgetting the licensing issue, the complainant is a business. So at the federal level, the Fair Debt Collection Practices Act protects consumers, but doesn't really reach into what I would call commercial collections, collecting from a corporation, if you will. If this wasn't a licensing case, would we have been involved at all with the complaint? The argument, the complainant is concerned because the respondent used social media essentially to call out the business for not paying their vendors. Would we even have taken that up hypothetically if it wasn't for the licensing?
It's a fair point, because it could be argued that the behavior violated the board's rules and regulations on communications with third parties. But when we have an unlicensed company, the department's stance is we focus on the unlicensed violation as opposed to any violations of rules or regulations, because the company has not availed themselves to Tennessee's rules and regulations by getting a license and informing
Right.
themselves.
So I'm asking, I want to generalize my question just one step more, and I'm not going to take us 30 minutes into a conversation. This is just a point I'm trying to understand for myself. Does the Tennessee collection laws cover commercial collections, or are they just designed to protect consumers?
Unfortunately, this morning, my computer went through an untimely update, but it's a very good question, and I'm going to pull up the statutory section. My understanding at this point in time has been the Tennessee Collection Service Act basically defines what collection service is, but does not specify that the collection of any form of indebtedness must be from individual consumer. It basically states if you engage in essentially a third-party collection
Okay.
action of a form of indebtedness in the state of Tennessee, then you would need to avail yourself. Now, there are exceptions. So essentially, if, you're a bank or a state institution, that you're exempted underneath the Tennessee collection statute, but I don't believe collection service, which is the defining activity, limits it to an individual. However, before I misspeak, I'm trying to pull it up, and I'll
Okay.
cite that exact
Well, no
statute.
rush. I was just thinking hypothetically after reading the report, would we even have taken that up? Because it's a commercial, what I would call a commercial collection. And the Fair Debt Collection Practices Act, Public Law 95-109, is specific for protecting consumers.
Correct.
Which has allowed the commercial collection industry to run a little bit wild in their approaches, including things like posting on social media and things that you're not allowed to do when we're protecting consumers. So anyway, it was just a,
No, it's a great question because it defines the scope of the board's jurisdiction.
yeah.
Fortunately, I'm usually on top of this, but as you can see,
Well,
my
you-
computer is moving at about half the speed of a snail.
yeah, that's okay. And that can be a follow-up for later. I just had that question.
If
So-
at all possible, I would like to answer that question during this meeting, but maybe we could circle back around to it once my computer gets back up and running.
Super.
I think it's a fantastic question.
Other than that, I have no real questions I personally don't have any questions about the legal report.
Okay.
I do have one question.
Yeah.
I'm curious, I know we have,
Your
But-
mic, your mic.
Oh.
Thank you, Tim.
we have 6 consent orders, as you mentioned, $500 apiece, which is $3,000. What percentage of that do we actually collect? Will we collect all of it? Or do some just choose not to pay?
I only know since I've been the attorney for the board. I can tell you every single consent order that you all have authorized that was not, essentially that I issued, did not meet with counsel afterward, get more information. As you all remember, over the last couple of years, we had a couple of complaints represented where like a material piece of information from the respondent was not communicated until after. With those, I think, 2 consent orders to the side, every single consent order that we have issued has been paid
Wow.
and has not been turned into collections, as in I saw the check come in and then close the case officially for the board. I believe there were 2 off the top of my head that we issued, and then they presented us more information that changed the fact, and then the board reconsidered, and then we closed.
That's a great question. So it's not just that we're issuing these orders, we're actually collecting on them. That's great.
Thank you.
One thing also I would like to bring up on that point, before I read the complaint numbers into the record, as you will see in the recommendations, it's slightly different than what I've put in before. I have plus costs, and I would like to explain that to the board, okay? So in the instance that I issue a consent order, we give them our 30-day response deadline. Essentially, hey, this is a settlement offer. We know this violation happened. You can pay this check, sign this agreement acknowledging the violation, send it back to us, and then we'll close the case. If they do not respond within that 30-day period, they don't correspond with me at all, we then move forward with formal legal action, which would be the filing of a notice of hearing and charges, which essentially starts a lawsuit with the APD judge system. A lot of times, that notice of lawsuit spurs the motivation, believe it or not, to then reach back out to me and say, hey, that offer that you sent us, 45 days ago really looks nice. Can we circle back around to that? The legal department's position on that has been we circle back around and then offer the consent order to still get these closed. However, there's time put into the drafting of a notice of hearing and charges. If we do not seek the refund of those expenses of like attorney's time for drafting that, essentially the board is eating it. We have changed our policy within legal department to where if someone does not respond to me with a consent order, we file a formal legal action, and then they reach back out, we are asking to resolve that matter. You will pay the $500 civil penalty or whatever we originally offered you, plus my time of drafting the notice of hearing and charges, and then the filing fee with the APD court system, which is $200, so that the board is not responsible for eating those costs because essentially a respondent did not cooperate or respond on time, and we had to initiate formal legal action.
So in that example, just pulling numbers out of the air, that $500 could have become $900. You should have taken the deal when we first offered it.
Exactly. And essentially, we're not increasing a civil penalty out of spite. We're just saying, hey, these costs have now been incurred because you didn't respond in the 30-day window that we gave you. In order to close this, you'll pay the same civil penalty plus these incidental costs.
Love it. That's great.
One other thing I haven't done, you all have told me before on the record at board meetings that you would prefer all of these cases, if they go forward with legal action, be heard by an administrative law judge. I assume that is the same idea that the board has, but just for clarification purposes, I guess I should say, we need a motion to approve the legal report?
Yes.
Hold on. My internet is now working. Sorry, I'm jumping everywhere. I want to read the statutory section so that you guys feel comfortable with everything that you're.
Okay.
My internet is back up, so I apologize. All right, I apologize for that wait. 6220-102 3 states collection service means any person that engages in or attempts to engage in the collection of delinquent accounts, bills, or other forms of indebtedness, irrespective of whether the person engaging in or attempting to engage in collection activity has received the indebtedness by assignment, or whether the indebtedness was purchased by the person engaging in or attempting to engage in the collection activity. Collection service does not include any person that engages in or attempts to engage in the collection of notes or guarantees. So the definition of collection service does not focus on.
Yeah, okay, great. Thank you. So it covers all kinds. So in the event this was a licensed agency, and I agree with picking that as, but if they were a licensed agency, then we would have,
Focused on the communication aspects of the complaint. But since essentially they have not availed themselves of Tennessee's rules and regulations by becoming a licensee, we don't hold rules and regulations against them and focus on statutory violations, which here would be unlicensed activity.
got it. Thank you very much.
Yes, sir.
That's
Absolutely.
great.
I apologize for that delay.
No, it was good. Let's get the right answer the first time, and technology is technology, right? Do we need a motion to approve the legal report?
Yes, we do.
Let's read it first.
Okay. I will go ahead and read in the complaint numbers. Complaint 202-500-6761. Complaint 202-501-2991. Complaint 202-501-3131. Complaint 202-501-3321. Complaint 202-501-3431. Complaint 202-501-7551. Complaint 202-501-8991. Complaint 202-501-2391. Complaint 202-501-4221. Complaint 202-501-5541. Complaint 202-501-7691. Complaint 202-501-9471. Complaint 202-501-9731. Complaint 202-502-3211. Complaint 202-502-0861. Complaint 202-502-5691. Complaint 202-502-2121. Complaint 202-502-3741. Complaint 202-502-6011. Complaint 202-502-8321. Complaint 202-502-8551. Those are all the complaints.
Now we'll take that motion. I'll make the motion. How about that, that we accept the legal report?
Thank you.
I second the motion.
Thank you. Thank you. We have a motion by Chip, a second by Jason. All those in favor to approve the legal report with legal counsel's recommendations, please say aye.
Aye.
Any opposed? Hearing none. Thank you. Do we have any rule updates? I will leave it with Joe here for another minute.
Good morning, board members. Just a quick update on our Collection Service Board rules that we started working on last year. I have great news. They've been officially reviewed and approved by the Attorney General's Office for Constitutionality. They were filed with the Secretary of State and posted online on June 26, 2025. The rules go into effect 90 days after being filed with the Secretary of State. So our rules will be going into effect September 24th, 2025. It was a long journey. I appreciate you working with me on that, but those are officially going to be in place. So we got that rulemaking achieved.
That's great. Congratulations.
Thank y'all. No, congratulations to y'all. So.
Thank you, members. On our new order of business, and then I'll make sure that if there are any questions, anything else the board wants to address, want to make sure that we don't have anyone participating virtually with a hand raised, and I just see that that's our team on the Teams call, and no one in person regarding any comments or questions about the agenda. So I have nothing else at this time. If the members do, we can address. Otherwise, we would need a motion to adjourn.
Anything, Tony? I think we're good. Then we need a motion to adjourn.
And I second.
Oh, I make the motion to adjourn.
Motion by Chip, second by Jason, and I've got us ending at 10 a.m. All those in favor, please say aye.
Aye.
Any opposed? Hearing none. Thank you, members, for a great meeting. Love it.
I've always wanted to do that.